decision not to attend.
Understood. Thank you.
So after trial, it always becomes to me a little less critical. Well, maybe it's never critical from the DA's perspective, what to say to the judge at this particular juncture. I feel like the DA's job sort of is done at this point, and we're expected, or it's expected, that we make a recommendation. And I've thought about it, obviously. There's sort of, as there always is, those two sides to this whole thing. Ms. Rapkin has reached what I would call an it here today. Around the corners. I think she didn't tell the truth about what happened out there. There's always the possibility she's convinced herself at some level that that's what happened. It didn't. And that's something else I know this court will have to balance, I guess, when you look at it. It's a disorderly conduct. I know back in the day when this all happened, lawyers were on TV. This should be a battery. This should be a battery. Well, not under our laws. It's not a battery. It's not. It's a simple question. There's no bodily harm here. I know in other states, a battery can be doing something to someone to cause them insult or, emotional injury, whatever. We don't have that law here. And this notion that this was something legally, criminal law-wise, more than a disorderly conduct, it's not accurate. It was bad enough. I mean, what she did was bad enough. It's spitting on someone is just so, as I said, it's just so degrading. It really leaves them with no response. And you can tell in that video that, Eric was upset, to say the least. I think, it's other people stepped in, they protected him, and those people protected her, Ms. Rapkin, from anything that could have happened, because people were angry, you could tell, about what had happened. So I don't really have a specific recommendation for the court. I've talked to people in my office, what's the right thing to do here? Well, the beauty of being the district attorney is I don't have to make that decision. Again, with all due respect, you do. And I think you can make the argument for some jail time here. I do, in spite of all the goods for her. I don't think it would be inappropriate. And I don't mean 90 days or anything like that. But I also think, you can sort of make the argument, yeah, but, and those are strong arguments to some degree as well. But when I look at what she did here, and what she did at trial, I have a hard time not saying that, if only for this, I don't know if punishment's the right word, but it seems that's sort of the only word we left to punish her, that some jail time, I would ask the court to consider that. Thank you.
When I hear the word punishment, the first thing that comes to my mind is the different ways that can be inflicted on a person. Certainly this court could just give her 90 days, 30 days, 60 days. You can impose whatever jail sentence you want if you think that's appropriate. And there's no ambiguity or misunderstanding here as to the court's power to do that if the court feels that's appropriate. But when I think of punishment, I think of things also like collateral consequences. And I don't know that, certainly Ms. Rapkin could have entered a plea in this case. It's always the dilemma when we have a trial. She didn't. She exercised her right to have a trial. And she has now been on bond for about 3 years on a criminal case. Not quite 3 years. We're coming up on the 3-year mark, but she's been on bond that whole time. And she's been perfect. And so I think about the punishment that's been inflicted on her, and we touched on it a little bit in our sentencing memorandum, but what horrible collateral consequences she suffered because of the things that happened in here and the decisions she made in this case. Stephanie, before this happened, by every account, comes before this court with, I would argue, the best character of pretty much any defendant you could ever see in court. A 40-year track record as a practicing attorney, a homeowner, a member of the Shorewood community, somebody who had published books as a lawyer, who had taught at the various law schools, Madison and Marquette. She's done guest lecturing before, and who has devoted herself to representing thousands of people. She's done estate planning work, and she has a litany of satisfied clients throughout her career. And were Stephanie to not have found herself in this situation, I don't think any of the collateral consequences we're talking about today would have ever unfolded. I think there was and you heard all the testimony, you heard all the facts, and this video has been played over and over and over, so the court certainly has plenty of information to work with. But in terms of a punishment that she's suffered, it has been tremendous. She was arrested. Mr. Griffin talks about jail. She was taken to the Milwaukee County Jail for 4 days, straight time, with no release, in handcuffs, in isolation during that time, having not even received a traffic ticket in her life, no criminal contacts at all with the criminal justice system, and she goes from upstanding member of the community to public enemy, I don't want to say public enemy number one, but a social pariah, you might say, somebody whose reputation was ruined. And she can rebuild it. She has a life ahead of her, I have no doubt about that, but it has been seriously affected as a result of what happened in this case. After her arrest, Stephanie's law practice had to be shut down, so she's no longer practicing. She's dealing with an OLR complaint. She's dealing with the civil lawsuit that's been initiated against her. She's dealing with a criminal prosecution here and a companion criminal prosecution tied in with this case. She spent God knows how much on legal fees. It's cost her so much financially, emotionally, really across the board in every respect. I think that, and you see that there's family members who care about Stephanie. There's people who came here to support her at trial, and there's people who Stephanie does not want anyone to speak on her behalf, but I know there's people who would be willing to make statements and speak on her behalf because there's so many people who care about her. And they know that she is not the type of person that's been painted, perhaps.
If you bend the mic top down, it's not going to give you the feedback.
Is that better?
Better.
Yeah, thank you. And so what happened after this, of course, is that Ms. Rapkin was labeled as a racist, as somebody who engaged in this behavior because she was part of some anti-BLM person. And the people who know her would say nothing could be further from the truth. That's not her character. She's not a racist. Her family members would say they wouldn't associate with her if she was expressing those types of views. She was somebody who probably was more aligned with a BLM side of things than a non-BLM side of things. And she's lived such an upstanding, good life. As a member of the community with good character, she's somebody who's helped people throughout her life. She's helped people in her legal career. She's helped run charitable foundations. And the last 3 years have been an absolute living nightmare for her. Those are the consequences that she's had to deal with as a result of this. I think that when you look at the severity of the crime, as Mr. Griffin said, it's a disorderly conduct. This court presides over much more high-level matters and more serious cases, carries a 0 to 90-day range. I think the time served is appropriate in this case, given that Ms. Rapkin did serve those 4 days in custody. I don't see any rehabilitation I really don't see any probationary needs here, and that's why we didn't ask for that. She's been on bond now for 3 years. There haven't been any issues during her time on bond, and there wasn't any issue before this incident happened. And I think I don't have the magic ball that can tell you why this happened. I think it was just a confluence of a really unfortunate series of events where Ms. Rapkin found herself in this situation and made a bad decision, and a jury's convicted her for that. But I think the collateral consequences, the reputational harm, the impact on her law practice, the impact on her as a person, the mental suffering and the emotional anguish that she's dealt with throughout this time is really significant and ought to be considered by this court at sentencing. For those reasons, I'm asking the court to impose time served. Thank you.
Ms. Rapkin, what would you like to say?
Nothing, Your Honor.
Are you sure? Okay. So at sentencing, the general objectives of sentencing are clearly to protect the community, to punish the defendant, to rehabilitate the defendant, and to deter others from like conduct. In preparation for this sentencing, I did review all of my trial notes, as well as review the defense's sentencing memorandum. I don't know if the parties noticed, but in the e-filing system, I sent in emails that I received 3 emails from, I believe, a friend of Ms. Rapkin's. I think this might have been the individual that was present during the course of the trial.
If I could comment on that, initials DH, I believe. We do not know who that person is. He identified himself as a UWM student. I asked Ms. Rapkin, we don't know who that person is.
Oh, okay. I assumed it was a friend. They were basically calls for leniency or dismissal,
Right.
or things to that effect. But I just wanted to make sure that you were all aware. I was surprised to receive them in my email, but I immediately dumped them into the court file. So I did review all of that in preparation for today's date. At sentencing, what I need to look at is past record, and you're right, Ms. Rapkin has lived a pro-social life. She has been a contributing member of the community. She has had a viable law firm that she practiced at. I did read that she wrote the 2 books, I believe, on estate planning or probate, something to that effect. And it sounds like without even a traffic ticket, she's lived a positive life in our community. I need to look at her personality, character, and social traits at sentencing as well. And a lot of the comments that have been placed in the sentencing memorandum, as well as the comments made here today by defense counsel, have reflected that that Ms. Rapkin has many positives. But you can't discount what happened during the course of this trial as well. You know, it's an interesting case in that we are here on a misdemeanor disorderly conduct. It's a Class B misdemeanor. That means the maximum potential penalty on this case is a $1,000 fine or imprisonment for not more than 90 days or both. No matter what happens here today, Ms. Rapkin, you have the rest of your life in front of you. If I gave you the maximum, you still have your whole life ahead of you. Now, looking at what this is, you know, when you look at the general scope of cases and disorderly conducts, you know, quite often in life, for someone's first offense with the criminal justice system and the first time they're before a court, quite often it is a probationary sentence or things to that effect. And the reason for that is that the probation by law should be a sentence unless a sentencing court would find that it would unduly depreciate the seriousness of the offense. In this case, when I reviewed the testimony that was offered at trial and I went through all of it, there were some certain parts that jumped out at me. And when I went through my notes from trial, there were some points that caused me great concern. So ultimately at sentencing, I need to look at Ms. Rapkin's level of remorse, whether or not she's repentant, whether she's cooperative. Today she's made no statement, but she did make a bunch of statements during the course of the trial. And I think that that plays into that. Now, of course, no one is penalized for bringing a case to trial. That is your constitutional right, and I enjoy doing trials. That's not the issue. The issue for me was her testimony. You know, when I look at what Ms. Rapkin did on that date in question, and we watched those videos umpteen times, you know, is it serious? Is it serious to spit in the face of this young man? Yes, it is serious. Prosecutor indicated, his word was, it's degrading. You know, what I thought of is it's disrespectful, it's demeaning, it brings someone to the lowest point. So is it serious? It is serious. You know, it's not a battery. Battery is a Class A misdemeanor. That would have, you know, thinking about the cases, or any way it could have been a battery, I guess if she had spit in his eye and it caused pain to his eye, then that could have been a battery. But that's not what we had here, and that's not what he claimed here. He's indicated and he testified that she spit in his face. You know, during the course of, I think, the trial, the argument was, well, he didn't wipe it off. But I can tell you, handling sexual assault cases and handling shootings and a number of other things, victims don't always respond like we think they should respond. Victims don't always give the proper answer or the proper bodily response that you'd anticipate, but that doesn't mean that crimes don't happen. So ultimately, when I consider the seriousness of the offense and I consider the character of the defendant and the life that she's led up till this point, I need to look at the needs of society, and is she a good risk? You know, she's presented during the course of her entire life being a good risk in the community up until this event. And watching the video, I do agree with her testimony where she said, I panicked. I panicked. I found myself in this situation and I panicked. I abandoned my car and I walked off, leaving behind my purse. But then she went on to say, I just thought I wanted to be safe. I wanted to be safe, and there was no way to get into the store except through the parking garage. But in the video, she walked past the ability to enter into the premises. She went on in her testimony to go on and to indicate that her intent was just to get back home. And she indicated that she spit and she saw it, and I didn't spit in his face. That didn't happen. That testimony was reiterated. She again stated during her testimony, I did not spit in his face, I did not spit on him, I spit on the ground. During the course of cross-examination, at that point in time, the video was played. And at 5:02 on the video, she indicated, I am not denying I spit on the kid. It was said, I believe, 2 to 3 different times during the video, I spit on the kid, which is very different than the testimony that she provided at trial. And that's the part that caused me great concern, because she went on in her testimony when questioned to indicate, no, I never told the police, I didn't say I spit on the ground, but I wasn't being articulate. I was scared out of my mind. And they walked back through the testimony again. And she testified again, I did not spit on Eric Lucas. Ultimately, the trial testimony, I think, ended at a crescendo at the point where the prosecutor said, I interview at your house? And she said, yes. And his response was, so the recording misrecorded you? And the response was yes. A trial, their concern is more I think your sentence would be at a different